Too small for me to steal.
Okay, let's get started again. Now, over the break, Dave Radoy asked me, when we did this field sobriety training seminar a couple months ago, Brian Crane and I were a couple of the volunteers. And we set out with a mission that morning to drink a large quantity of alcohol to get us up over the 08 legal limit before I think it was 10 or 10:30 in the morning.
In other words, it was a normal day for you.
We succeeded. It was a great Friday, let me tell you. It was a great Friday. Now, both Brian and I ended up at .17, and that was when we were tested on the field sobriety tests. And frankly, anybody who scored any clues on me aside from the eye test was wrong, because I passed all those tests. And I know this because I was still quite capable and clear enough to be instructing the students on what they were doing wrong. So, I knew I was passing. Now that said, what you heard from Fusco about, once you've got alcohol on board and how you can take this alcohol in your mouth and you can fake the machine when you're violating the rules, I disagree with John's assessment that, well, that requires you to violate the rules. What you're doing in those instances is you are intentionally setting up a hypothetical scenario that the Datamaster should flag. This is my .17 that I've got it set on my device to read out to 3 readings, .297. All right, so that's a 17 turned into a 30. Not hard to do. I've got another one here that was a .217. These are all taken just 10, 20 minutes apart. Now, I didn't go up that high. Instead, what I was doing was just trying to see how high I could get it. When John talked about overflow detected, I get that a lot. When I play games with the machine, I get that a lot because I push it too hard and I get it up over a .6. Point being, though, is that I've gotten scores way up there. You get enough alcohol on board, and you can do this. Where that counts is with gastroesophageal reflux disease. I don't know where you all want to go with this. I'll talk about GERD just so you understand what the problem is. But as John was describing, A.W. Jones came out recently pretty much strongly in support of the idea that GERD could be a problem. Not saying that it is a problem, but it's potentially a problem. What we've got is, we go back to that human diagram where we've got the mouth, the esophagus, going down to the stomach. Such a high percentage of people have gastroesophageal reflux disease that it's a great defense. Gastroesophageal reflux disease is acid reflux.
Okay.
You keep burping, you keep belching. In extreme situations, the person has a tendency to spit a lot because they taste that puke in the back of their mouth and they're constantly. That regurgitation continuously happens, and the stomach acids will erode the esophagus. They'll actually get little white spots that are like precancerous. They'll get ulcers. They will also dissolve that upper sphincter muscle that stops the stomach. And one of the surgeries that they do for this is that they go on in there and they crush that thing and break it apart so that it's no longer hard so it can move again when they have these surgeries. But the problem there is once it gets bad enough, the top stays open all the time. I had a young lady that came into the office a few years ago. This is another common sign of gastroesophageal reflux disease. She was going to a dentist for special treatments because her teeth were eroding away. The stomach acids will erode the enamel of the teeth. And so these are real problems, okay? Now you've got a person who's consumed alcohol but has gastroesophageal reflux disease. We've seen from the data that you saw earlier this morning that even on an empty stomach it can take 75 minutes for the alcohol to become fully post-absorbed. Well, if it's not fully post-absorbed, where is it? Chances are it's still in the stomach. And if that alcohol's in the stomach, this is a great area of cross-examination for an officer. The Datamaster cannot ascertain the source of the ethanol that it's measuring, plain and simple. When John was showing you this here, this is slope detection. I don't know if he came right out and said this is slope detection. This is slope detection, all right? It's looking to ensure that there is a proper slope and not a negative going slope. That's all that it is, all right? And the Datamaster's taking 4 readings per second while it's making these calculations. So this curve that you see, well, I guess he did get that there. 1, 2, 3, 4, 1, 2, 3, 4, 1, 2, 3, 4, 1, 2, 3, 4. And then it gets these negative going values and it says, oh my, that's an alcohol spike. Now when it doesn't flag it, and clearly it doesn't flag it, and this has been written a lot in the literature, okay, this is a failure on the behalf of the Datamaster to detect the alcohol slope. Now how did I do it? Well, I had alcohol that I consumed or even spit out mere moments before, and then kind of huffed to try and get some of that extra alcohol off, and then I blew fast, and I blew hard, and I blew short. And I stopped here before it was able to get that negative going value. When a person has gastroesophageal reflux disease, though, this alcohol from the stomach, we're talking molecular levels of alcohol here. So it doesn't require a lot to get that number bumped up a bit, and if it's not able to detect a massive amount of alcohol, such as the difference between a 0.17 and a 0.29, then is it going to really detect that small amount of alcohol coming up from the stomach? The gas is combining with. And from Listata, we know that the deep lung air is not what's actually being tested here. It's the deep lung air plus the alcohol from the esophagus plus the alcohol from the stomach. It's a great and powerful defense, but it really requires adequate presentation of evidence to the jury, and it also requires the jury to want to not convict your guy, okay? You might have a client who is actually innocent appearing before a jury, but if they don't like him and they want to believe that the cop saw red glassy eyes, slurred speech, staggered gait, couldn't do this test, couldn't do that test, couldn't do the next test. I had a jury a few years ago, 2 years ago I want to say, it was 5 women and 1 man, and there was just nothing I could do, and they were all old biddies. And I mean, they looked like biddies. You hear about biddies? They looked like biddies. I had almost everything in the case suppressed. There was no breath, no blood, no nothing. All that we had was a video, and the guy's about 50 yards away on this crappy old camera, and he's doing all the various tests. You see him doing all the tests. You can't hear slurred speech or anything like that. The cops didn't say it there was slurred speech. They said that he couldn't do this test right. And I said, who cares about this? What does that even mean? Well, 5 biddies did. They convicted him just on that. So, I mean, you might have the best case in the world, and if the jury doesn't want to return a not guilty verdict, that's why you've got to, you got to learn those trial skills like you do at the CDAM's trial college. You got to persuade them. You got to really wrap them up in the flag type of thing and get them interested in the case, get them interested in justice, get them interested in your client, because the science is only part of it here. So you've got these tools though that you can use. The other thing, we talked about temperature earlier, and I kind of missed the boat on that one. I skipped over something too quick. With temperature, you've got an internal body temperature and you've got this expired breath temperature. There's a significant difference between the two temperatures. Just in blowing out, it decreases in the temperature. Now I know that I covered that you've got the 6.8% per every degree, but this expired breath temperature, it's not written in stone as to what it actually is. Okay, there's no general agreement as to what expired breath temperature should be. And when John was giving his presentation, there was something that came up about temperature there, but this is all Henry's law, constant temperature is assumed. Well, if the constant temperature is a different temperature, then you're going to have a bad simulator test. If this thermostat or the thermometer is off, or if this thing heats up too much, then you're going to get a higher result. The hotter it is, the higher the blow. The colder it is, and this is interesting, when John was talking about the studies, I practically couldn't contain myself. You can get college students to do so many interesting things for $5 to $10 an hour, especially if it involves free alcohol. Imagine, if you will, drinking a large amount of alcohol and then lowering yourself into one of these sports baths that goes up to about your neck, but filled with ice water, and then blowing into a Datamaster, or it wasn't actually a Datamaster, it was one of the other breath testing instruments. But imagine doing that. How much fun would that be? And sure enough, it lowers the core body temperature, and you come up with a lower reading. And that's Henry's law, okay? In terms of kind of shifting gears on over to the administrative rules, and to the national scene. I thought that this might be interesting for you because, like I said earlier, when I met Rod and his wife down, the New Mexico couple, at the National College for DUI Defense, I became keenly aware of the fact that we are very isolated here in Michigan. We've got these handful of criminal defense organizations, but it's almost like we live in a vacuum. So we don't really know what's going on in other states. There are states that are much worse than Michigan when it comes to their breath testing programs. I don't know if you've been reading the news, but there was in terms of blood testing, there was a toxicologist out in Boston recently who was dry labbed. She was actually falsifying some tests that were negative, saying that they were positive for cocaine, and there's something like 30,000 tests that have gone, all thrown up into the air now. Criminal charges against her. This is their state's version of a Michelle Glenn or a Dr. Felix Adatzi, and that would just blow your mind if either one of those folks were falsifying data. I mean, they might not be nice people, they might not be on our side, but for them to engage in criminal acts, that would, no, I wouldn't think that that would ever happen. Well, sure enough, this is their version of that sort of a person falsifying 30,000 some odd cases. It's crazy. All right, now breath testing programs are subject to the same problems. I told you earlier about Washington State having all their stuff online and all that, and wow, Washington State lawyers, they've got a powerful DUI defense bar out there. They are the ones that compelled them to put these things online. And yet just a couple of years ago, they had these state ampules similar to what we're using. Their state lab person who was mixing their ampules of alcohol falsified a whole bunch of documents and had things fraudulently executed by a notary. Just crazy stuff, to the point where there were criminal investigations and this person fled the state of Washington. That is nuts. Well, first off, why would you do that? And then the answer, of course, you realize that, oh my God, it was pure laziness. And yet, it matters, okay? And maybe one of these days we'll have a big scandal here in Michigan. I don't know, but so far we haven't had much in blood or breath testing and alcohol, at least. Now, in some of the other states, you won't see one particular breath test adopted. You'll see several. Ohio is a good example of this. John is actually competing with other breath machine manufacturers down there. The state patrol went, I think, the Intox 8000. They picked it up a while back, and then they dropped it, if I'm not mistaken. But the way that the state patrol goes is usually how a lot of the local jurisdictions will go. Well, Ohio has been a Datamaster state because that's where the instrument is manufactured for the longest time. So for them to go outside the state and to go with a company that refuses to release the source code, that's interesting. But I think that there's been I think that they took that back and that they've gone with some other direction now at this time. But you will see breath machines that are competing with one another so that one department's using one, another department's using another, and they're free to pick whichever one that they want. In other states, there's a state evaluation process done. Alabama actually rejected the Datamaster, said that it was too unreliable. Now, you heard John today in his presentation. Frankly, I don't know what happened down in Alabama when they evaluated the Datamaster. Something funny, though, because the Datamaster will pass the minimum requirements that any of the major breath machines that's out on the market needs to pass. So I don't know exactly what it was that went on down in Alabama, but you saw that in that state, Datamaster was rejected. It's good stuff, though, to use against maybe a police officer on the stand. That isn't it true that this machine was investigated and then rejected in the state of Alabama? And you've got a published paper on it. Now, some states have different rules. There might be a 20-minute observation period. We've got a 15-minute observation period. Is anybody here not really familiar with the administrative rules or the Datamaster handbook? Okay, a couple people. Well, I'll tell you what. You can get this through Freedom of Information Act. There are some copies online. I think I've got the 03 online. I've got the 07. I've got the 07 here. You've got it online?
Well, I have it on my iPad. I can
Yeah. Okay, good. And then I think Nichols posted after the last CDAM conference, he has a copy of the 2012 DMT, if I'm not mistaken. There is a new DMT, and for whatever reason, I can't.
Stuff off that.
Oh, maybe it's 2010.
I
Yeah.
got it on
The
my.
DMT
Yeah.
one hasn't been, that I know of, hasn't, you can only get from John at this point.
No, no,
I've
no.
not
It's
seen it out yet.
Michigan State Police sent me out another copy of an 07 for a case
I think he
recently.
put up the
No, they
07.
they
No,
said,
I'm
oh,
talking about the
yeah.
most recent DMT. It's not
I've
out
got
yet.
it on my flash drive. If
Yeah.
anybody wants it, you got it.
Well, can you send it to William so that he can?
I don't know how you can send it. It's so
How big is it?
I don't know, but it's probably huge. Oh,
It's not
Is this
big.
published by
It's
the MSP?
there. The MSP's FOIA division coordinator just doesn't realize that it's there, and I think that one hand doesn't know what the other one's doing. But this sets out for you how to run simulator tests, how they mix the solutions. A lot of this stuff is going to be going to the wayside because these wet bath simulators, and Bart, you asked me to do a simulator, and I apologize, I can't. This one's programmed the Ohio way, and it wants to accept the simulator through the rear panels, which we do it through the front here in Michigan. But this is a wet bath simulator. These are very expensive, these Guth simulators. $600-700, which you look at it and it doesn't seem like much, but because it's NIST certified and all that, it's got to be traceable, they're expensive. And I've heard several people asking, you know, what's the problem? Why do these results on these simulator logs, which I've got copies of some old simulator logs here. From 05, I just grabbed them out of a random file. Oh, here they are. You know, you've got chicken scratch from all these various officers all over it. They've got the results of what it is that came up. I think that even now, oh no, it's got the supervisors. Notice that there's no supervisor signature where it mandates that there be a supervisor signature because the supervisor, I guess, is too lazy to sign it until you complain. Then we have the notorious Marv Geyer, his stamp right here that certifies that it's in good working order. This is the 120-day inspection, all right? Marv is an employee of National Patent Analytics Systems, and if you'd like to have an interesting read, order a copy of the contract bid documents from the state of Michigan regarding the Datamaster. One of the things that was a requirement in the Datamaster, or in the breath testing contract, is that the manufacturer had to agree to maintain the equipment. That pretty much excluded everybody except for Datamaster because John was the only one that was willing to make employees available to do this. And so he has to employ 4 or 5 Michigan people to run around the state running these 120-day simulators. Now, Marv will run several different wet bath simulators. And if you were to go down to National Patent Analytics Systems, you would constantly hear this humming, stir of the simulator tests because they're all over the place. They keep them plugged in constantly, and they only change the alcohol solutions in there when they have to. Otherwise, they're just constantly running. They'll plug it into this Datamaster, they'll plug it into that Datamaster. They're constantly using the different standards. Marv will go into a police department and run solutions at 08, 15, 20. You can order these records from National Patent Analytics Systems. You just call down there, and they'll say, well, which instrument are you looking for? You'll give them the number. The serial number is on every one of these Datamasters. I don't know if that's actually... The one back there's got it on little sticky tape, but you can tell from the Datamaster ticket. This is the one that I purchased from National Patent Analytics Systems, so it's a working good model. That one back there I got off of eBay, like I said earlier. This one, its number is 950276, which means that it's been in service since 1995. The first 2 digits indicate the year that it was put into service. The vast majority of Michigan Datamasters are 93 and 94. I have seen a 92, maybe a 91. I'm not sure about 91, but but they've all been in service now for a long time. I guess 92 is 25 years. So they were built to last a long time without having to be taken out of service. But at the same time, you've also got this great argument that, hey, This particular device that we tested my guy on has been in service for 25 years. And some of them have been pulled. There are some major problems that occasionally will occur with these devices that can bring into question the accuracy and reliability of the test. Never use Marv Geyer or a person from National Patent Analytics Systems to try and prove that, however, because they will always take the position that if the machine produced a result and not an error code, that the result was an accurate result to the best of the instrument's capabilities. And even though you're kind of just guessing, well, what about the issue that occurred? And their answer will just repeatedly state that this is what it is. In terms of how the breath testing is done, it's set forth in this manual here. It's done step by step. You can turn to it and it's got it written out in police officer speak. Rule number 1 is to check the subject's mouth for any foreign objects. And I want to say that it's breath, blood, tobacco. Check mouth of subject for blood, food, gum, tobacco, or any foreign substances. Observe subject for at least 15 minutes. Record observation start time on evidence ticket. Use the time displayed on the instrument panel only. That's step 1, and you'll see so many police officers that don't follow step 1 and don't even know what step 1 is. And it's laid out step by step by step in terms of how to conduct these tests.
It doesn't really matter much anymore.
I know. Well, no, it does to jurors, though. It does to jurors.
Yeah, to that extent.
Why does it matter?
Why does it matter?
It used to be that
The judges don't care, is what he's saying.
Okay.
And the judges don't care.
But we
it
can
goes
still
to
talk
weight,
about
not
it, though, I mean.
admissibility.
Right.
Right.
You used to be able to get cases kicked on a violation of the administrative rule, 15-minute observation.
And now you have to like talk to a jury about it forever.
Well, that's interesting because we are probably the only state, or one of the only states, that has it set up in this fashion, where we've got these administrative rules. And that's, I guess, because I didn't do a PowerPoint, and I am a little tired, and I apologize for this. Purpose and intent of this afternoon was going to focus first and foremost on those administrative rules. I want to take you back to law school. I took this horrible class that bored the heck out of me. It was called Administrative Law. And it deals with the Chevron doctrine and things like that, and whether or not the EPA was able to pass benzene regulations that couldn't be complied with by industry standards, et cetera, et cetera, et cetera. And man, oh man, that one would just put you to sleep. However, it's very pertinent and very relevant to breath testing. We've passed these rules, and the courts have looked at those rules, and under the old people, v. Schwab, and some of the older cases that you see where they say, the administrative rules were passed to ensure accuracy and integrity of the breath testing program, and a violation of those rules requires suppression of the breath test when those rules are not followed. And then we fast forward to People versus Wojciechowski and People versus Rexford, where somebody makes a pretty stupid argument, let's be honest. Rexford is that, well, there was an error on the Datamaster 6 months ago where it didn't make a simulator test. And they moved to suppress. And the court said, no, that seems like a technical violation. What was wrong with the device on the date in question 6 months later? Are you alleging that there were any other errors? No, just there was this error 6 months ago on the simulator line. And you said it, Judge. A violation of the rules requires suppression. And the Court of Appeals, of course, kind of nodded its three heads and said, well, that's kind of technical, don't you think? Wojciechowski was a case where the subject claimed that he was not properly observed for 15 minutes. They all have been spanked by this one by prosecutors before. Wojciechowski says that the officer's allowed to look away for a few seconds. Well, yeah, but if you read Wojciechowski, the problem wasn't that the guy looked away for a few seconds, it was that there was another cop standing there watching him. Now, we've done a great deal to water down these administrative rules, but you look at the Chevron doctrine and how this is all supposed to be set up. The lawmakers passed a law. That law said the Michigan State Police, or the Department of Michigan State Police, shall be responsible for promulgating rules and procedures that accomplish the following: That is an enabling statute. It's no less an enabling statute than when Congress says, and the EPA shall implement the Environmental Protection Act. Once they've passed that enabling statute, it gives pretty much unbridled discretion to the Michigan State Police to do their due diligence to try and get the best breath testing program out there. But of course, when you put the Michigan State Police in charge of the breath testing program, you're almost putting the fox in charge of guarding the hen house. So in other states, we'll see the Department of Health or something like that. They don't do any better of a job, though. Maybe even less, because they just don't care in these other states where they're given the rule-making authority. But in any event, the Michigan State Police did. They sat down, they made these rules, okay, and those rules are the administrative rules. You shall observe a subject for 15 minutes. If there's an invalid if there is a subject sample deviates more than by 0.01 at the 08 standard, a second test shall be offered, all right? If the second test deviates by more than 0.01 or 0.02, depending upon where the scale is, a third test shall be offered. If the subject refuses, or if the third test is not in compliance with the first two tests, then blood shall be requested, and if necessary, a warrant shall be drawn up. These are, they address themselves in terms of shall do this, and shall do that, and shall do that, and shall do that. Then under that, they've got this, the Michigan Datamaster Handbook. These are their procedures. All right, the EPA, when they pass rules to say that this is the law, or these are the rules that everyone's going to follow, they also have their own internal procedures. This is what their own agents shall follow. And this is what the Department of State Police's agents shall follow. Now, a few years ago, I raised a lawsuit because they changed the way that radio frequency interference was working with the Datamaster. They just up and changed the handbook here by saying that you shall not have a radio in the room, just like Borkenstein had recommended years ago. They said you should not have it in there, and that was after People versus Fosna came down. Fosna was an invalid sample. Guy blew into the machine, produced like a 0.15, then he blew into it a second time and produced an invalid sample. And he said, aha! There was alcohol in my mouth. And of course he was probably right. The court really didn't care, though. They said that the handbook, which is not binding but is authoritative, says that if there's an invalid sample, the officer should begin a new 15-minute observation period. So the Michigan State Police just jumped on that bandwagon and started putting should everywhere that they could. And so radio frequency interference became should. And radio frequency interference is a big deal, though. It's a big deal, though, in other states primarily, where, again, different rules in different states. One test, and that's what Rod and his wife were asking me, was, are you a single blow state? Can you imagine having one of your clients go on into the police station, they blow into the machine once, and that's good enough. There's no verifying result. There's nothing to confirm it.
Michigan?
What's that?
Can't we have them refuse the second test?
You are allowed as the subject arrestee to not do the second one. The second test shall be offered, is what the rules say.
Okay. Oh, shit.
In other states, it's a mandatory 2, and in other states, it's a mandatory 1.
Now, if you can
In
give them
Michigan,
advice
it's
beforehand.
mandatory 1. The second one is optional for the arrested person, but mandatory that the officer offer it.
Like from a defense attorney perspective, if you could give them your advice beforehand, would you say to not do the second test? Because oftentimes it only verifies the results of the
True.
first one, so then you have more to challenge if it's only one.
I don't... 6 of one, half dozen the other, Who knows what's going to happen on that second test? It might...
Because sometimes it could be off. And
Exactly. Exactly. Now, I would advise somebody who gets an invalid sample to always refuse the next one. Because where John was a little mistaken there, he doesn't know what Michigan's position is on this. In these procedures, it tells the officers that an invalid sample is not a refusal. They acknowledge John's theory about inconsistent blows and that sort of stuff, but their internal handbook does not make concessions for it to become a refusal, even if the officer says, well, he got that invalid sample erroneously. The problem is this, is he was telling you about the 525 megahertz chopper wheel spinning around there, and how quickly it's able to do that. these 4 breath tests per second, I don't care how inconsistent you're blowing, no person is capable of tricking it in 1 second. Before you ever get to the point where you're intentionally making an invalid sample, it's already way past you because it's doing 4 per second. And all it needs is 2 negative going values before the invalid is tripped. Yes?
Just so I understand it then, if you get an invalid sample, you've satisfied the implied
You have
consent.
satisfied implied
And
consent.
therefore, you don't, if you have an implied consent here and you have a affirmative
I
defense.
walk into those all the time and win. I just say, it was an
You
invalid.
complied and that was it.
And, but what's interesting though is this. More often than not, your client is terrified and doesn't know that an invalid sample satisfies implied consent. What do you do in the case where your client goes in, blows an invalid sample, and the cop looks at him and says, well, there you go, you dumb son of a bitch, now you're going to lose your license. Unless you blow for me again, it's coercion. It's the person is submitting to the claimed lawful authority of the officer. The second test is not shall being offered, it is shall being demanded by that officer in those instances. And I've seen that a lot, and I think that it falls under that North Carolina v. Bumper, U.S. Supreme Court case that says if the cop tells you you have to do it and you just submit to that lawful authority, that's not consent. And if they don't get it through consent, they certainly don't get it through the rules. Now ultimately though, we've got a problem. When I filed my lawsuit against the Michigan State Police a few years ago over this radio frequency interference, I gave them my grand scheme of things as to my version and view of the administrative rules and the context under which the breath testing program exists. And they said, oh, you're lying, you're so wrong, you're wrong, and they denied everything. Yes?
Bill, I got a court-appointed matter, and you just brought up a point that I didn't even know, but I'm looking at the BAC ticket, and they put refused for the second sample, but in the police officer's report, he puts that the subject just stated he didn't want to take a second test.
Right.
So, wouldn't that BAC ticket be reflected incorrectly then? I mean, if he...
The first, is there a result?
refusal to say, if the
You can,
ticket
you
says...
can actually put refusal.
Oh, yeah.
You can still put refuse
Oh,
even
yeah.
though he...
But it's not an implied consent
Okay,
issue.
it's not an implied
Right,
consent
right, right.
violation. Okay, gotcha.
Because he took the one test, and that's all that
Okay.
you're obligated to do.
Okay, gotcha.
So I espouse my theory about this way that these rules work, and the Michigan State Police denied everything. And like last year, they produced a PowerPoint presentation. Perry Curtis and the prosecutor guy whose name always escapes me. They basically put together a PowerPoint presentation where they adopted all of my arguments, where they made all these denials, and it was kind of funny. I was like, hey, didn't I read? What it is this. If we look at the Federal Department of Transportation, I mentioned to you earlier that all these preliminary breath tests are on the list. All of the evidential breath tests you've ever heard of today, including maybe some others that you've never heard of, like the Lion something or other. They're all on there. You can look it up. It's in the Code of Federal Registry, and it's there. This 2 or 3 page, it's called the List of Conforming Products. And it's a long list, and it's got everything going back to the breathalyzer 900A. That old one that you saw there, the Dial-A-Drunk, is on the list. It doesn't fall off the list. All that needs to be done in order for it to comply is that they say, all right, well, it's got to measure within this and this so many times. And then it's got to measure this and this so many times. And it's got to measure this so many times. And what you do is you bring your device in and you give it to them. You're allowed to set it up, and then you have to leave the room. And the people that are doing the certification run it through simulator tests. So that's all that it needs to do is pass these various simulator tests before it's on the list of conforming products. Well, the Michigan State Police, in their sage wisdom, said that any device that's adopted for use as an evidential breath test shall be on the Federal Registry list of conforming products. Well, okay, that's as a minimum, right? I mean, we're not going to start using the breathalyzer 900A, are we? Well, we could, I guess. Or we could just switch on over to the Alka-Sensor 3 because it's also on the list, or the LifeLock FC10 because it's also on the list. Judge Teresa Brennan out in Brighton went ballistic crazy on me when I was trying to suppress the Datamaster because it was never adopted. And we had a radio frequency interference issue in it. And I said, and that book was changed without notice to the public, and if an internal rule is changed to the detriment of someone in the public who has standing, then that person has the ability to challenge it. Motion denied. We're ready for trial. You know, so, but you get something like that with the EPA, where they're affecting big business, and that's the sort of litigation that will drag on for years, and the EPA will actually back off. Not the Michigan State Police, because they're not even required to answer when you're in front of Judge Brennan. She's just going to say denied because she doesn't get it, and she doesn't want to get it. And then I say, well, Judge, I've got an 07 PBT that I want to introduce. And she's like, well, PBT doesn't get in. And I say, well, one, it's exculpatory, and two, it's evidential. What do you mean it's evidential? Well, it's not coming in as exculpatory. The statute is very clear on its face. It doesn't come in. And what do you mean it's evidential? I said, it's right here on the same list. Prosecutor whipped out this list 2 days ago, Judge, and he said, look, Judge, it's on the list. And I'm saying, look at the same list. It's on the list. Denied. I know that I was right, okay? These are all on the same list, and the Michigan State Police could change their mind tomorrow as to which breath testing instrument they wanted us to use. That is done on a closed bid to the lowest qualified bidder type of thing. And we all know, if we get that contract, that the only qualified bidder is Datamaster, because they're the only company that's willing to have representatives here. And that brings me full circle back to what's going to happen in the future. Wet bath simulators, because you have to have cops operating these things and they don't know what they're doing, they're going to go to the wayside. All right, they've got these dry gas simulators that John was talking about. The dry gas simulators will go off every Monday at a specified time, every Monday. It measures it, it's done. Okay, so it's all automated. It's going to kind of suck because you're no longer going to have a person you can cross-examine on this to say that it was working properly. They'll just introduce some records and say, oh yeah, it was working properly. According to the gas simulator that was run on Monday. Now, in other states though, they don't play games with this. Wet bath simulators might be a pain in the butt to run because they got to be running, they got to be warm, you got to plug them together, you got to hit simulator and all that. Dry gas simulators are all automated. So we switched over to dry gas simulators because they're going to be so much easier and take out all that room for error. Well, in other states, they have it run once before the first subject blows and once after the subject blows. So you've got a simulator test, subject sample, simulator test. So that we know that it's there in that realm and that it hasn't drifted. Why don't we do that? Well, because I guess we don't really have to, because the state police make the rules, but there are worse states. There are states where they don't have to run a simulator but once every 6 months on a breath machine. Can you imagine that? So different states handle these things differently. So we will see the wet bath simulators go away except for Marv Geyer. Marv is still going to be running around with his kit of fancy stuff, doing his tests on these things. But Marv almost never comes into trial. He's just running that 120 to see that it's maintaining all those various levels. And you don't really want Marv coming in because he's not going to help your case. I'm trying to think if there's anything else.
Any argument, significant argument when they skip Marv Geyer 120-day test?
You make an argument that his statement is hearsay, that it runs afoul of Crawford because it's testimonial when he certifies that the machine is working properly. There's counter arguments to that in the Crawford line of cases because it is merely administrative or equipment maintenance.
He doesn't do it.
Oh, if he doesn't do the 120,
Yeah.
well, he always does the 120.
I got a case for you. It's not in the records. He forgot
I'd be
to put it in the
surprised.
records.
No, Marv would have created, you'll find a separate sheet floating around with just his stamp on it. And there'll be a big long record that you can get from National Patent Analytic. Now there are times when he misses it by a couple of days if there's something weird that happens. But, I mean, this is all that he does and he's pretty good at it.
Well, I have all the records, and I have the one that he does, and he wrote in it that he didn't put it in the...
Oh yeah, he'll say that he didn't put it in there because he couldn't find the logbook. That always raises some interesting questions though. When the logbook's not there, where's it at? It's supposed to be with the Datamaster. A couple of DUI lawyers a few years ago did a surprise visit on a police department. This is not here in Michigan. But they got the judge to order that they were allowed to go into the Datamaster testing room with their expert and take a look at the surrounding area and the logbook. And they got into the room and they made copies of this. It's hysterical. They found the logbook that had like a, oh no, I'm sorry. The logbook was all written up proper. There was a big sticky ticket on the breath machine. It said, if there are any problems, do not write it in the logbook. Call this number instead. Because they didn't want to make a record of the problems. And they got burned. Trying to think of any of the other interesting differences with other states. Obviously in other states like New Jersey and Florida, they've obviously got some better judges that are more open-minded to some of the technical issues of this. I don't know why we don't have that here in Michigan. I don't know if it's because our judges are elected.
Can you say federalist?
I don't know. I mean, there's some good judges here. Why don't they do it? Why do they become so embittered, or I don't know, as to why source code litigation hasn't taken off, as to why my administrative challenges, when I think that I was right. I mean, they've adopted my, oh, I'm sorry, I never closed that up. With the administrative rules, Perry Curtis and this prosecutor have now got that PowerPoint presentation I was telling you about, and they acknowledge that, yeah, we're in charge and we get to change these rules as we like, and they will if they so desire. One of the some of those changes that occurred, look at how the courts have treated it. The rules were just changed a few years ago with Rexford and Wojciechowski and Fosna. They incorporated those judicial decisions into the rules, saying that, oh, let me see if I can't find it, if it's even in this book yet.
The observations.
Right, there you go. Thank you. Yes. Sorry, I'm getting tired.
That was one of the changes. And did they
One of them?
Did they change the radio frequency from the 03 book to the 07?
It was changed from 03 to 07.
Okay. The multiple officers with the observation was a huge change.
Yeah, a person may be administered breath alcohol analysis on an evidential instrument only after being observed for 15 minutes by one or more appropriate class operators before the collection of the breath sample, during which the person shall not have smoked, regurgitated, or placed anything in his mouth except for the mouthpiece. The observation may be conducted by more than one operator working in concert. Now the thing about administrative law is that when an administrative body decides to make a change, when there's a court decision that comes down and they say, hey, we acknowledge that court's decision, we're going to change our rules and embrace it and incorporate it into our rules, whose decision is more important? If Wojciechowski says that it's okay for the guy to look away for a few seconds while the other cop's watching him, and then the rule says that it shall be conducted by one or more class operators. And Wojciechowski, I don't think that the guy was an operator. He was just another cop. Technical, if this guy's not an officer or not a breath test operator, let's just assume for the sake of the argument that it was a little bit more clear and unambiguous. If it says in those rules, post-Wojciechowski, that only Class 2 operators or above shall be permitted to engage in the observational period, and you have the exact same facts of Wojciechowski come up again after the rules have been changed, and you've got the Class 2 operator looking away for a few seconds, and you've got this cop who's not a Class 2 operator standing there. Oh, but I saw that he didn't put anything in his mouth. Don't care. I don't care what Wojciechowski says. The Michigan State Police made their rule change. And you can honestly go into any court and say, Judge, they took your Wojciechowski decision, they incorporated it, and they said that no, it's going to be Class 2 operators. Would you be right? You would. these rules, these administrative rules, can incorporate court decisions and overrule court decisions. If a court decision came down that the Michigan State Police didn't like, they could pass a rule and say, we don't like that decision, and that's not what we're doing. So it's up to the Michigan State Police. Now try to convince a judge of that, though. Try to convince a district court judge that, no, I don't care what the Court of Appeals said, Judge, the Michigan State Police changed the rule. Didn't you take administrative law in law school, Judge? Because he's going to smack you around that time and tell you not to lecture him about administrative law, that he knows what the court decision was. Anything else that you all want to talk about, or you want to get going?
I wanted to mention something. Alan has been so kind, he's actually got a copy of the DMT training manual now on the flash disk.
Okay.
And I think he's going to be able to send it out to you. And
I've got a copy, but I don't know where it's at. It's on PDF.
he's going to be able to send it to all of us if you meet up with Alan.
Give me your email addresses, come over here and put it in your notebook.
Oh, anybody did not get a certificate, if you want to get a certificate, just write down your name for me and I'll get it for you. I apologize, there was somehow I missed a couple people. If it's no big deal to you, if you don't want one, that's fine too, but it does look good on the wall. You can tell a client, look, I took a certified Datamaster course, or whatever it is you want to tell them, I don't care. You tell them, I took more training than most Michigan police officers, and my training was from the president of National Patent.
One of the things that I wanted to just, you know, I'm using the voice of advocacy because, Alan, one of the things that I wanted to say is that we have a golden opportunity to educate these judges. And you can't forget that because we are not educating them at their Judicial Institute that they go to in July.
Right, yeah.
So if you use those nice little CDM techniques we teach you and try to make the trier effect join you in the search for the truth and saying, wait a minute, administrative, like with Bill's problem with administrative rates, they weren't adopted, they were adopted because of scientific considerations. The reason for a 15-minute observation period is well documented all the way back to National Patent's early research. The reason to make sure that you're dealing with a real sample is because these are scientific machines that are known to have interference with them. So this is to outlaw that. I'm more interested in seeing you post some more about the dry gas stuff because that is very new.
Yeah, well, you know, and I'm just, one of the reasons, aside from John just being a nice guy and an impressive speaker, the reason why I wanted him up here is because I just don't know enough about the DMT to even talk about it. I need to get my hands on one. I've experimented with it down at National Patent. You know, if you take their class, by the way, man, they just whip out a few cases of beer for the whole class, and you actually sit there and drink beers at National Patent Analytic and get to play around with their Datamasters. I could not get one of these .29 tests generated on the DMT. And I think that it's because what he was talking about, that 5% difference down at the end, I couldn't get it to trigger that sort of a thing. But on the back Datamaster, I can do it all day long. But I need to actually have one in my possession. I'm going to have to break down and buy one here pretty quick and start to play around with it.
How much do those cost, Bill?
Yeah, I think, you know, John is really reasonable if you're an individual person purchasing these. $2,000 to $2,500, I think. But the actual market on them is $500 to $6,500. I think the state of Michigan is paying $6,000.
Elkins is going to buy us one for that.
Yeah. Buy you one for Christmas.
You know, Mike, don't you agree, though, that you've seen these judges with these administrative rules and
What's that?
everything seems to be just like, the judges are ruling that these are just technical violation, goes to weight versus admissibility, and I haven't been that successful. It seems like years ago it was a lot easier to get things thrown out and suppressed as a result, but it just seems like every judge now is just
Well,
saying.
here's another really great defense, okay? FOSNA. You know, FOSNA, you read that case and they say, we don't care that it was an invalid sample. We don't care that there's mouth alcohol. That goes to weight. Do you know how many times I get a case where I walk on in and I got a .15 and an invalid sample and I say, officer, did you engage in the requisite 15-minute observation period? Well, we don't have to do that. Well, no, you don't, but it implies the presence of mouth alcohol, doesn't it? Well, yeah, but still, I didn't have to. It says I should do it. Oh, okay, I'm sorry. When it says you should do it, you just figure, I don't care. And these jurors, they come back not guilty. So, take those cases where those judges are telling you, well, it goes to the weight, not the admissibility, and win those cases. You can still fight them. Now, of course, there are crappy decisions out there where they say that the weight of the evidence, where, you got some cop that does this, and that's the whole HGN test, and they say, well, that goes to weight, and you're like, that wasn't even the test. That's ridiculous nonsense, and you got to fight that. But when it actually is, when it does boil down to, like that urine test in that case I showed you, Miller, I think that the defense did have a fair opportunity to fight it in front of the jury, and the jury didn't like the client. They said, we think that he was hammered, and if you read the other facts, he sounded pretty hammered. So, the jury was sitting there going, urine test, he's hammered, he's in an accident.
See, and when you have, just a quick comment, when you have the balls to tell the jury to go out and, just for FSCs for 1 second, have the jury, have the balls, do it in closing and say, go really try this, okay? Go try to really see if you can stand on your leg at a 6-inch level for 30 seconds.
Technically, you shouldn't be asking the jurors to engage or conduct experiments, but...
Technically. But that's...
So somebody objects to it.
It's within their purview to do it in the jury.
Well, I guess, Judge, you have to order them not to do these things.
They can do.
I've asked jurors to do it.
Yeah,
And
I have
actually
too.
said jurors said they couldn't do it.
Not like they went to the scene of the crime or something.
And you're, in fact, my client took
You
emphatic
have to use your common sense. I had a juror, had a situation where a guy threw a girl in the pool by putting his hand in the garage.
Thanks again.
Thank you. Yeah. Thank you very much. I'm happy you came.
Yeah. So I'll be coming to any more of you
Okay.
offers. So DRE, I want to
DRE. Next time, hopefully it's somebody else doing all the talking, and I'll just sit back there and smoke cigarettes and stuff.
Sounds good to me.
Like mine.
Thanks again. You're welcome. You're very welcome.
I know you said you're going to